एकदा प्रशांतकडे जाऊयात याच संदर्भातली अपडेट घेण्यासाठी. प्रशांत,
राज्यपालांच्या निर्णयाबद्दल सुनावणीच्या दरम्यान सुद्धा खूप ताशेरे मारलेले होते सुप्रीम कोर्टाने आणि आता तेच निकालामध्ये सुद्धा प्रतिबिंबित होतंय. कारण सुप्रीम कोर्टाने एक महत्त्वाचं विधान केलेलं आहे की जे पत्र राज्यपालांच्याकडे दिलं गेलेलं होतं त्या पत्रातून सरकारचा पाठिंबा काढला गेलेला आहे किंवा जे रिझोल्युशन मूव्ह केलं गेलेलं होतं त्याच्यामधून कुठंही हे स्पष्ट होत नाही की या सरकारच्या स्थिरतेला धोका होता आणि त्याच्या आधारे राज्यपालांनी निर्णय घेणं हे पूर्णपणे बेकायदेशीर होतं. दुसरं एक महत्त्वाचं विधान कोर्टाने हे केलेलं आहे की राज्यपालांनी अशा पद्धतीनं बहुमत चाचणी बोलावून एक प्रकारे पक्षांतर्गत फुटीचा प्रश्न सोडवण्याचा प्रयत्न केला जो पूर्णपणे असंवैधानिक आहे. कारण त्यांना अशा पद्धतीनं अधिकार नाहीये आणि त्यामुळं राज्यपालांची कृती ही पूर्णपणे बेकायदेशीर आहे हे सर्वोच्च न्यायालयानं सांगितलेलं आहे. कविता, हा लगातार तिसरा मुद्दा आहे की जो शिंदे गटासाठी धक्का मानला जाईल. पहिलं म्हणजे भरत गोगवले यांची व्हीप म्हणून नियुक्ती, दुसरं म्हणजे आम्हीच खरे पक्ष आहोत हा बचाव आणि तिसरं राज्यपालांचा हा बहुमत चाचणी बोलावण्याचा निर्णय.
एक अत्यंत महत्त्वाचं वाक्य, राज्यपाल कोणत्याही पद्धतीनं अगदी छोट्याशा मुद्द्यावर सुद्धा पॉलिटिकल भूमिका घेऊ शकत नाहीत असं सुप्रीम कोर्टानं म्हटलंय. पुन्हा एकदा सुप्रीम कोर्टात जाऊयात.
However, the lack of security to the MLAs has no bearing on the question of whether the government enjoys the confidence of the House. The appropriate response of the governor in such cases is to ensure that security that they were lawfully entitled to continues to be provided to them if it has been removed. This was an extraneous reason that was considered by the governor. The third communication that the governor relied on is the letter dated 21 June 2022 addressed by Mr. Eknath Shinde to the Deputy Speaker, stating that the appointment of Mr. Ajay Chaudhary was illegal. The governor may not inquire into or express an opinion on the validity of proceedings of the legislature. That is exclusively within the domain of the legislature itself or in certain circumstances discussed in the previous segment of this judgment within the domain of courts. The discretionary power of the governor under Article 163 of the Constitution is limited to situations where a constitutional provision expressly provides it or where the Constitution cannot be construed otherwise than to grant such discretion. Hence, the governor ought not to have relied on the letter dated 21 June 2022. In any event, the contents of the letter did not indicate anything to suggest that the then Chief Minister, Mr. Thackeray, had lost the confidence of the House. Finally, the governor relied on the letters written by Mr. Fadnavis and 7 independent MLAs, calling upon him to direct Mr. Thackeray to prove his majority on the floor of the House. First, both Mr. Fadnavis as well as the 7 MLAs could have well moved a motion of no confidence. Nothing prevented them from doing so. Second, a request by some MLAs for a direction to the Chief Minister to prove his majority does not, taken alone, amount to a relevant and germane reason to call for a floor test. There must be some objective material in addition to a mere request to call for a floor test. In the present case, the governor did not have any objective material before him to indicate that the incumbent government had lost the confidence of the House and that he should call for a floor test. And the exercise of discretion by the governor in this case was not in accordance with law. Now on relief. Relying on Bommai and Nabam Rebia, the petitioners argue that this court has the power to restore the status quo ante and rule that the government with Mr. Thackeray as its chief minister is to be reinstated. However, this argument does not account for the fact that Mr. Thackeray did not face the floor test on 30 June 2022 and submitted his resignation. This court cannot quash a resignation that has been submitted voluntarily. Had Mr. Thackeray refrained from resigning from the post of the chief minister, this court could have considered the grant of the remedy of reinstating the government headed by him. The order of this court dated 29 June 2022 held that the outcome of the trust vote to be conducted on 30 June 2022 shall be subject to the final outcome of this batch of petitions. Since the trust vote was not held, the question of it being subject to the final outcome of these petitions does not, therefore, arise. Conclusions. In view of the discussion above, the following are our conclusions. A. The correctness of the decision in Nabam Rebia is referred to a larger bench of 7 judges. B. This court cannot ordinarily adjudicate petitions for disqualification under the 10th schedule in the first instance. There are no extraordinary circumstances in the instant case that warrant the exercise of jurisdiction by this court to adjudicate the disqualification petitions. The Speaker must decide the disqualification petitions within a reasonable period. C. An MLA has the right to participate in the proceedings of the House regardless of the pendency of any petitions for their disqualification. The validity of the proceedings of the House in the interregnum is not subject to the outcome of the disqualification petitions. D. The political party and not the legislature party appoints the whip and the leader of the party in the House. Further, the direction to vote in a particular manner or to abstain from voting is issued by the political party and not the legislature party. The decision of the Speaker.
सगळ्यात महत्त्वाचा मुद्दा की अविश्वासाचा ठराव आणता आला असता पण तसं न करता एका पत्रावर विसंबून राज्यपालांनी बहुमत चाचणी बोलावली